before lunch we were looking at Justification and the judgment of Lord Justice Leggett, which provided some guidance on the matters to take into consideration in the Justification balancing exercise when determining whether or not the measure is manifestly disproportionate or the legitimate aim, the adverse impact is manifestly disproportionate to the legitimate aim. And we touched upon the basis of discrimination. Race, we looked at what would ordinarily be the case where Parliament has the measure is contained in legislation and Parliament has confronted directly the cost, and I made submissions distinguishing that. And both of those matters were ones I took your lordships to in respect of the judge's assessment of this case in relation to both race and Parliament's consideration. Now I'd like to turn to another factor that he weighed in the balance, which is the question of the scheme's efficacy. So, no question it pursues a legitimate aim, but the judge considered it relevant to take into account in the scheme's application and the question of its justification on its rollout and how it is actually applying in practice, the extent to which it's efficacious in achieving that aim. And he concluded, and he gave the matter detailed consideration at paragraphs 111 and 112, that there wasn't any evidence to show that the scheme was proving efficacious, and there was in fact evidence to show that it wasn't efficacious in achieving its aim. So if your lordships can turn to pages 93 and 94 of the core bundle, you'll see the detailed consideration that the judge gave to the matter. Many factors that he took into account, and on top of that, if your lordships can just briefly skim that, all factors going towards showing an absence of efficacy and also critically the failure of the appellant itself to try and evaluate the efficacy of the scheme now it had been implemented. And to that the appellant says and criticises the judge for addressing efficacy and taking it into account in his assessment of manifest disproportionality, on the basis that, and this is at footnote 3 of page 7 of their skeleton, that it's difficult to measure the efficacy of the scheme. So the judge was wrong to take any of this into account because it's very difficult to measure its efficacy. And the appellant relies on paragraphs 47 to 49 of Mr. Asmat's statement. For your lordship's note, that's at supplementary bundle 102 that starts. And in our submission, he was perfectly entitled to take the view that he did for the reasons that he identified in reliance upon the multiple sources that he did rely upon. And also, I'd ask your lordships to look at the statement of Mr. Chai Patel, again, both his first and his second statement. So I'd ask your lordships, if you haven't already done so, to read paragraphs 70 to 83 of his first statement, which is all concerned with efficacy and monitoring, or the lack of monitoring on the part of the government, and his second statement at paragraph 10 and 11, and that is SB 45, and then further evidence contained in JCWI's 2017 report, Passport Please, at page 334 forward. And what this shows is not only that there is a possibility of making measurements as to the efficacy of the scheme, but it also makes manifest how the government itself has done absolutely nothing to measure the efficacy of the scheme, nor, save for its inadequate survey valuation, to measure its discriminatory effect. And this is despite the fact that the government itself has recognised that it needs to do that. And where it recognised that is in the supplementary bundle at page 364 in a Home Affairs Committee hearing. It's page 364 of the supplementary bundle. Starts at page 364. We can see the Home Affairs Committee. There's oral evidence on the Windrush scandal. And if your lordships turn on to page 365, you can see that it was then Home Secretary Sajid Javid who was being questioned as a witness, together with Glyn Williams, who was the Director General responsible for Borders, Immigration and Citizenship. And Q284 and including 284 and 285, my lords. So we have here a scheme which at the time of implementation, Parliament does its best to look forward and analyse how it is likely to operate in practice. It confronts benefit against cost on the basis that it thinks that the measures that are being put in place to prevent discrimination are going to be effective. So it recognises a risk, it takes steps to mitigate that risk. The government is then confronted by multiple sources of evidence once implementation has taken effect, after a bedding in time, and continuing, consistently showing that implementation and operation has not gone according to expectation and to Parliament's expectation. And yet the government does nothing either to evaluate its efficacy or the extent of its discrimination, when the cost, i.e. of discrimination, is not even something that has been properly taken into account by Parliament. Now, in our submission, that failure to evaluate falls to be taken into account in justification, precisely because, through evaluating, the government will be able to identify or answer the relevant questions to carrying out that evaluation of where the fair balance lies. It will be able to identify the extent of the discrimination, it will be able to identify the efficacy of the system and balance the two against each other. And in our submission, that's exactly what the PSED duty is for in a case such as this, the public sector equality duty. And this case is in no sense distinct, in this respect, from a case called Coll, Supreme Court case, Coll and the Secretary of State for Justice. And this was a case concerning bail hostels. It's the Authorities Bundle tab 33, which I think is the first Authorities Bundle.
What is that, 33 or 23?
33.
It's the second one.
Oh, sorry, second one. So from the head note, this is a female who was sentenced to life imprisonment for murder, and she anticipated that if she were released on licence on expiry of her tariff, she would be likely required to live in premises approved by the Secretary of State. That's really a bail hostel. And between D&E, 4 more lines down, placements were generally made as close as home to possible, but the problem women faced is because of the very small female prisoner population, there are hardly any such approved premises, and therefore women suffered discrimination because they were far more likely than men to be placed well away from their homes, thereby interrupting and interfering with family life and private life. If your lordships can turn to paragraph 42, is the conclusion of Lady Hale, and what the implications are for being in breach of the PSED, Public Sector Equality Duty, for justification of the measure. Now, I recognise this is a justification under the Equality Act, indirect discrimination under the Equality Act, but in my submission, as a matter of rationality, it's no different.
Well, was that a case where the Ministry had not addressed the possible impacts at the time they passed the legislation?
I would have thought it's undoubtedly the case that they wouldn't have done so. And they certainly did not.
Sorry, is that comment?
Yes, it was a continuing, the point about it is it was a continuing duty. So you pass the legislation and then you've got to see what happens in practice on the ground to measure its discriminatory effect and its continuing justification. So, in our submission, the judge took account of a series of relevant factors, weighed them in the balance, and he didn't. There was no failure on his part to take account of relevant factors. So, for example, the EU directive that we discussed this morning, he looked at that, he considered it, it was taken into account by him, and I repeat the points I made this morning, that that is a directive which goes further than, no, sorry, it does not go as far as this scheme. This scheme is not implementing the directive, it is going further than required, and therefore one cannot justify this scheme on the basis that the directive was being implemented by its creation. And just in passing, there is a document which touches upon this, perhaps. It's at page 122 of the supplementary bundle. The impact assessment. Doesn't answer it, but it touches upon it, and it's worth noting. Bottom of page 122, there's a box, and the second line of the box, the second row, does implementation go beyond minimum EU requirements? And the answer to that is NA, not applicable, which would rather seem to suggest that EU requirements are not applicable or are not explanatory of the measure in question. And another thing I'd ask your lordships to know, we went to page 118 this morning, if you turn back a few pages. We went to 118 this morning because I led your lordships here rather than looking at the directive itself. But on page 118 we can see, and Sir James took you to this yesterday, this is back in 2011 that this document was produced. We can see how things stood on the ground in various European countries in terms of taking action against those who facilitate or help irregular migrants. And we can see under the heading National Legal Framework, the second paragraph, we can see some of those countries that are taking the harshest approach. And all I'd ask you to note there, my lords, is that the United Kingdom's approach under the scheme is the harshest of all of them, with a 5-year sentence of imprisonment, even where there is no intention.
What about Cyprus and Greece? The law set an explicit prohibition to rent property to migrants in an irregular situation.
Yes, but the point I'm making is that the most severe scheme is ours, where it carries a sentence of up to 5 years for contravening the legislation and committing a criminal offence. We do have, so in our submission, the judge was perfectly entitled to reach the conclusion that he did, and it was a conclusion that the scheme was manifestly without reasonable foundation. That's a clear conclusion he reaches in 1, 2, 3. And he did then go on to conduct the balancing exercise himself. And our alternative submission is that the manifestly without reasonable foundation test does not in any event apply to a case such as this. Because if one traces the emergence of this concept or test and its application in the cases that have come to the court's attention in this jurisdiction and in Strasbourg, they all concern matters of expenditure of state resources. They're all about the choices that a government should be free to make in determining how it should expend scarce public resources. And it's clear that that was the case in relation to STEC, which is where the word was first, or the term, the test first appeared. And that is, the STEC case is tab 59. All about social security payments. Paragraphs. And if you turn to JD and A and the UK in tab 72, see what the court then has said about this particular authority, the STEC authority. It's tab 72. And the relevant paragraph is paragraph 88. So this is the first benefits cap case that was here and then made its way up to Strasbourg. And this is the case which Sir James mentioned yesterday, in which the European Court of Human Rights has clarified the limited circumstances in which the manifestly without reasonable foundation test applies. Oh, sorry, bedroom tax case, first bedroom tax case. So paragraph 88, 6 lines down, towards the end of the line, thus even a wide. Thus, even a wide margin in the sphere of economic and social policy does not justify the adoption of laws or practices that would violate the prohibition on discrimination. Hence, in that context, the court has limited its acceptance to respect the legislative's policy choice as not manifestly without reasonable foundation to circumstances where an alleged difference in treatment resulted from a transitional measure forming part of a scheme carried out in order to correct an inequality. And outside the context of transitional measures designed to correct historic inequalities, the court has held that given the need to prevent discrimination against people with disabilities and so forth. So that's the position in Strasbourg. They identify a very limited basis upon which the manifestly without reasonable foundation test applies. As a matter of fact, it's the case that this principle or test has only ever applied in the context of the expenditure of resources. Now, we accept that this court is bound by the judgment of the Supreme Court in DA, but the judgment of the Supreme Court in DA goes no further than saying the manifestly without reasonable foundation test is what is applicable where one is dealing with the expenditure of state resources.
What about the Court of Appeal decisions?
They're all the decisions have been ones in which that has been the issue of concern. And if we go back to what Lord Justice Leggett, as he then was, said in the SC case, paragraph 87 of tab 45, he provides a straightforward account of why in that context, a very, very permissive test should be adopted. And that is paragraph 87 of tab 45. Starts with the third line down, just above B. Within the UK's constitutional arrangements, the democratically elected branches of government are in principle better placed than the courts to decide what is in the public interest in such matters. Those branches of government are in a position to rank and decide among competing claims to public money, which a court adjudicating on a particular claim has neither the information nor the authority to do. In making such decisions, the legislature and the executive are also able to, and institutionally designed, to take account of and respond to the views, interests and experiences of all citizens and sections of society in a way the courts have not. So, while this court is bound, as it were, by DA, there is in fact a Strasbourg authority which takes a different course, and all the cases so far have been ones arising in the context of state welfare, social security provision. This has nothing to do with the expenditure of scarce resources, this scheme, and there is no reason therefore to apply the manifestly without reasonable foundation test to justification. Can I then finally turn to the defendant's criticisms of the judgment in its skeleton at paragraphs 20 to 23, which are in the core bundle at page 20. It's neither the necessary nor the intended effect of the legislative scheme. Well, the judge fully took into account that it's not the intended effect. That neither absolves the state of responsibility nor does it in and of itself justify the scheme. The scheme has to be justified by reference to its cost. Its cost is race discrimination, for which there is no justification, i.e. a very high threshold of justification for something such as race discrimination and nationality discrimination, and we accept the threshold is lower for that. It wasn't contemplated by Parliament. They haven't evaluated it, and the judge found, on his view, it was the inevitable consequence of the scheme in light of the incentives built into it and the lack of efficacy of the measures, the protective measures that were built in because of the real world. So that doesn't take the defendant to the point of demonstrating that the judge erred in principle. And the second point I would make about what the defendant, or how the defendant addresses justification, is that what the defendant does throughout, and Sir James did this again yesterday, is the defendant focuses on justifying the risk of discrimination, because the defendant seeks to justify the measure as at the point at which the legislation was introduced. Because, as we looked at earlier, the defendant's argument is that one shouldn't look at this measure, the scheme as it operates, one has to judge its legality or compatibility with the convention, its compliance with convention rights, as a hermetically sealed legal document, as it were, irrespective of how it plays out in practice. And hence, it looks only to the risk that was identified by Parliament at the time. And for the reasons I have given, that is the wrong approach. This is a measure intended to have application in the real world, has had application in the real world, and like the case of DH, like the case of Roma rights, it is its effect that calls for justification. And so justification cannot be assessed by reference to the measures taken to address the risk. Justification has to be addressed by reference to the actual discrimination that has arisen. So again, nothing there is capable of impeaching to the point where this court can quash the approach of the judge taken below, because he rightly proceeded by looking at how this played out in practice. And finally, can I just take your lordships to a statement or an oft-used statement of, if you'll bear with me one second. Yes, can we turn to DA again? And the DA is at tab 43. And to the speech of Lord Wilson, where he quotes from a passage in the judgment of In Re G. He quotes Lord Hope. And this touches upon the issue that was raised earlier about the court usurping the function of Parliament. Should it come to a conclusion that this measure, with its discriminatory impact, is not justified? And Lord Hope said this at 56: cases about discrimination in an area of social policy will always be appropriate for judicial scrutiny. It's a key function of our courts to hold up individual rights, and the right not to be discriminated against on grounds of race is an absolutely critical constitutional right. The constitutional responsibility in this area of our law resides with the courts. The more contentious the issue, the greater the risk is that some people will be discriminated against in ways that engage their convention rights. It's for the courts to see that this does not happen. It is with them that the ultimate safeguard against discrimination rests. And that's what we're dealing with here. We're dealing with an unintended cost, unintended consequence, but a readily foreseeable and, as the judge found, inevitable consequence of this scheme, albeit it is as a result of landlords acting unlawfully and flouting the law in that sense, by refusing to follow the guidance. But it is having serious effects on British citizens because of their race, and on those who are perfectly entitled to be here and to rent because of their nationality. And the court should not in any sense run shy of evaluating and subjecting to proper scrutiny the reasons given for by the state for this result and consequence.
I note at paragraph 58, reference is made to James, United Kingdom, the leasehold enfranchisement case, which is hardly a matter of socio-economic policy. It doesn't involve expenditure of public resources. The court held the test there was manifest without reasonable foundation.
As I understand it, it was as a result of the James case that in re asbestos, which was Lord Mance's conclusion, that the manifestly without reasonable foundation test applied, but only to the first three stages of the four-stage test. That's how one ended up with that. 3 stages, manifestly without reasonable foundation, but fair balance is a matter for the courts, i.e. the approach that Mr. Justice Spencer applied in this case. So it did not lead to the application of a full manifestly without reasonable foundation test.
But my point was James can hardly be said to be an expenditure of public resources case.
Yes, but and my answer to that is that what that then led to is that the manifestly without reasonable foundation test in a James-type situation does not apply to the whole exercise of justification, but to the first three steps and not the fourth.
Okay.
So, can I then turn to declaration of incompatibility?
Yep.
So it's here that Sir James began yesterday with the cases of BB and Christian Institute, and relied upon them to say that whatever you find, unless you're satisfied that the scheme is going to discriminate in all or nearly all cases, you can't make a declaration of incompatibility. And in our submission, that is not what these cases say or mean. So, and I should outline what it is that in our submission these cases do say and mean before I take your lordships to it. So these cases are concerned to address whether or not, where in the individual case there is going to be an unjustified interference with a convention right upon the application of a legislative measure, provision, scheme, the measure, provision and scheme will not themselves be incompatible with the convention unless those interferences in the application of the scheme in the individual cases is something that arises because of a feature of the scheme itself, i.e. they inhere within the scheme such that it is inevitable that the scheme's application will result in that interference, that unjustified interference. And that approach is exactly the same as the approach the court takes to an unacceptable risk of illegality or unfairness in a policy, detention action type cases, to back, which we'll come on to look at. And that's what both of these cases that we looked at yesterday, BB and the Christian Institute, are concerned with. In both of these cases, as we'll see, you have a legislative scheme unquestionably gives rise to interferences in the individual cases on its application with convention rights, but the scheme itself is not incompatible with the convention because there is nothing inherent in the scheme that requires that result. And the reason there's nothing inherent in the scheme that requires that result is because the scheme confers a discretion as to how it is to be applied, and that discretion can be structured by guidance to ensure that decision makers act compatibly with the convention. So there's nothing inherent in the scheme that leads to that, to the contraventions in the individual case. So that's really what these cases decided. And if I can take your lordships to starting in BB 26, that's authority 26. And if we can look at paragraphs 53 to 55 in the judgment of Lady Hale. It's really 53 and 55. Your lordships read those two paragraphs.
Yes?
And then at 60. I would not strike down the rule or declare it invalid, i.e. I'm not going to make a declaration of incompatibility. It will not, well, it's a rule, so they don't need to do that. It will not be an unjustified interference with Article 8 rights in all cases. It is capable of being operated in a manner which is compatible with the Convention rights. And note the reference to operated. It is capable of being operated. There is nothing about this scheme that compels an unjustified interference in the individual cases.
The rule can be operated without a breach.
Yes, exactly. It can be operated without a breach. And for your Lordship's pen, 95 in the speech of Lord Newburger and 98 to 101 show his approach again. The concern is with the guidance. This is an attempt to challenge the legislation itself, but it can operate in a fair way. And then, in Christian Institute, tab
In the present case, it could be said the scheme could be operated without any discrimination.
in our submission, that's exactly what cannot happen.
It can happen. If landlords do what they're meant to do, it will happen.
Yes, but landlords aren't doing what they're meant to do.
Yeah,
and
but if they do,
how are landlords to be made to do what
well,
they're not doing
back
now?
to familiar ground, aren't we?
But how? The scheme has to operate in a way that means landlords don't do it. How?
They're capable of operation. That's rather different.
It's whether or not there is something you can do to the scheme to stop the discrimination. Now, as Sir James repeatedly said, what else can one do? The government has done what it can, it's done everything it can, and it cannot prevent that which has been going on since the scheme was introduced. What else can be done? The answer is nothing. Now, it may be that the government can come up with another scheme that isn't going to have this same effect. And if it can
Still
do
struggling to
so,
see how in your argument how they ever could.
well,
The landlords seem pretty determined not to have a scheme that works.
They don't want the hassle.
No, quite.
it is, in my submission, it is a step too far to, because the implication of that is that landlords are just being really bloody minded and they're just saying, we're not going to play ball with this. Whereas actually, what landlords are doing is doing their day-to-day business in the face of a scheme which they can sidestep by taking one course
Unlawful
and
sidestep.
code.
They aren't playing ball. They aren't playing ball.
But they're not doing it in the sense of saying we are just going to deliberately flout the law. This is something that de facto they are simply going to do by making that assessment of what it is in their overall interests to do. But it's not we are going to deliberately disobey this, such as the poll tax implications. It's a very different situation. It is the logic of the scheme that is giving rise to this. Now, it may be that there is another scheme that the government can come up with. And the whole point about a declaration of incompatibility, and this is a critical point, is it doesn't render the scheme inapplicable. It stays on the statute book. It continues to operate. And then it is down to the government to decide whether or not there are things it can do to change the scheme that will save it, or the government is free to decide that it's going to continue the scheme, or the government can decide it's going to introduce another scheme that in its view, and on the basis of a proper evaluation and assessment, it concludes is not going to have that effect. But the courts...
I'm sorry to interrupt. You say, in the terms of paragraph 60 of BB, you say that the statute here, the statute cannot be operated
Yes.
compatibly with the...
Yes. So if the court were to come to the conclusion that the government has not justified the discrimination that is arising in the scheme's operation, so you...
But it's not the scheme, it's the statute. We've got to focus on the statute.
Yes, the statute creates a scheme. So when I talk about the scheme, it is the scheme created by the statute.
But part of that scheme, in that sense, is the ability to do things by way of order of the Secretary of State. You have to show that the statute is incompatible.
Yes, I understand.
Not that the scheme as it now stands is incompatible. The whole scheme with policy and orders and all of that.
I'm taking that on. I'm taking that on. Sir James has said repeatedly, what else could we do in relation to this set of statutory provisions? What else could we do? And that is a premise or a statement that I
agree with. It's probably the only one he's made that I agree with. But what else could they do? There is nothing else. If we sit here and think, what is it that the government could do to make sure that landlords stop doing this? What? Nothing. There is literally nothing that can be done that will save this scheme. So when one asks oneself, is the discrimination that landlords are meting out, which on the judge's finding is a direct result of the scheme because it is the scheme that incentivises them to do it, and the measures to prevent them from doing it, the Code of Practice and the Equality Act, are not efficacious, then if that is what is happening under this scheme, the discrimination inheres in it. It is going to happen. It is not a situation such as in BB where you can issue guidance and say to landlords, don't discriminate. They've done that, and it's still happening. And the government cannot come up with anything else that can be done.
Well, that does seem,
further mitigate.
that does seem to suggest that no provisions of this kind can ever be valid on your argument. It can never be done.
Well, that is not, I cannot
slightly
possibly.
inconsistent, your
So,
approach.
for example, I've given an example. If you criminalise the deliberate letting to an individual, the intentional deliberate letting to an individual who has no right to remain, it does not follow that landlords would do this.
So
All the
if
incentives built into
the
the scheme.
statutory scheme could be tweaked by removing the words "or have reasonable grounds for believing," you said then that would be all right?
I'm
I'm not sure you would be conceding that.
Well, I'm not sure I would necessarily concede that at all, because the scheme works as a whole, and it wouldn't simply be the case that you... I mean, I'd have to think about that. I haven't thought about that. But as the scheme stands, it is the operation of all the component parts that create the incentive which is leading landlords to take the action that they do. You can't take one little bit out and say it would all be different. So if they went back to the drawing board, it's impossible to say that they couldn't come up with something that would achieve their end and not have the discriminatory consequences that this scheme has.
In your example of a simple criminal offence of intentionally letting to an irregular migrant, that would intentionally, I would have thought, necessarily would include or could include recklessness, which means that a landlord would have to ask for documents. You'd have to ask for evidence that the individual before him was a British citizen or had the right to be here, had leave to enter or remain. So you'd have to look for those documents.
They'd have to have subjective recklessness, so they'd have to be on notice that that person was an illegal migrant and go on regardless. It wouldn't be enough for it to be just...
So they could simply shut their eyes to the possibility of this individual being an illegal migrant.
Yeah, you'd have to show that they had a proper appreciation of that illegality and they went on regardless.
Right. Well, it's hopeless, isn't it? As an offence, absolutely hopeless.
Well, that is what the European directive requires. It doesn't require anything else.
Well, it depends how you read the word intentionally. It's astonishing to my way of thinking it doesn't extend to recklessness. Quite astonishing.
But I'm accepting it. It extends to recklessness. That's exactly what I've
That
accepted.
means you can't close your eyes to that which is before you.
So recklessness means you have to actually have a contemplation of the subjective recklessness, contemplation, which is the criminal standard, of the illegality, and go ahead regardless.
Well, let's say someone called Ramesh turns up wanting to rent and can't speak a word of English. Would that not, in those circumstances, given the legislation, at least indicate landlord should say, can you please give me proof of your status?
I personally find that extremely difficult to say yes. Everybody who turns up with the name Ramesh and can't speak a word of English is therefore...
It seems to me the directive has quite some importance for this whole debate. And had government taken any steps before the 14 Act to give effect to the directive in some other form?
There is an offence of facilitation. There was a pre-existing offence of facilitation.
Facilitation of
Of
entry.
of a breach of the so it's not just focused on
What was that in? Is that in the 2002?
facilitation of an
Was that in the
illegal
2000? Was that in the 2002 Act or what?
No, it's the 1971. Yes, we don't think it was just restricted to entry,
Right.
but it's in the 1971 Act.
If someone could just pin that down, perhaps in a subsequent note, that'd be helpful, Ms. Scuffman. Thank you.
I think it's section
Right.
25
Section 25.
of the 1971 Immigration Act,
Section 25.
which made it a criminal offence to facilitate the commission of a breach of immigration law knowingly or without reasonable cause.
1971 Act.
1971.
Yes, thank you.
Or without reasonable cause. And was anything further done, well, I don't know if it's James, in the light of the directive itself?
I'll double check. I don't think so, but I'll double check.
Right, that answers that. Anyway, thank you, Ms. Scuffman.
So just speeding on through, because your lordships have the point about what these cases are getting at. They're getting at a systemic problem. And just for further support of that for your lordship's pen, McLaughlin, tab 38, paragraph 43, where Lady Hale explains more about what she meant in Christian Institute, and again we can see it's the legislation itself which is going to necessarily result in breaches in the individual
McLaughlin
case.
is tab.
It's tab 38, paragraph 43, and then there's a new authority that I'd like your lordships to look at, and I'm sorry this isn't in the bundles,
Right.
but it's the source, or the Court of Appeal decision is the source of the observations by Lords Hughes and Hodge in Beebe about all or nearly all cases. Oh, I think I've got one. Can I have 3 copies up? And what we want to look at, so this is and Lebanon. This is once and Lebanon got to the Supreme Court, it was the Court of Appeal's judgment to which Lord Hughes and Hodge were referring in Beebe. Relevant paragraph is paragraph 56. And if your lordships will read 56 down to the end of the first line of 58. So you can see there that again it's this it's how it is inevitable because of the nature of the legislation. And we refer in our skeleton to the case of T and the Chief Constable of Greater Manchester, and that's this case is another application of that principle. That's the authorities 23. And here we have a scheme. This is the criminal record certificate schemes, and the criminal record certificate system established whereby the police are obliged to make disclosure of information contained in criminal records to prospective employers of the prospective employee. It's given rise to a lot of litigation because it has led to very disproportionate consequences for individual applicants as a result of the application of the legislation. And that's arisen because the legislation has been very blunt in its early manifestations or iterations. So, for example, and that's what T is concerned with, If an individual has 2 convictions, then they necessarily must be disclosed. Doesn't matter how long ago they happened, doesn't matter that the person was a child, doesn't matter how unserious they are or trivial they are, they have to be disclosed, and that can then have a very deleterious effect on an individual securing employment. So the critical point about this is, and the paragraph we need to look at is 52, is that in most cases, in almost all cases, the application of the legislation to the particular case will not be disproportionate at all, because it is tailored, but there will be some cases where it won't be, and that is because of the terms of the scheme itself. It is inherent in the scheme that this small number of cases are inevitably going to result in disproportionate disclosures. And the court granted a declaration in that case because it was the scheme itself which was leading to that inevitable consequence, and there was nothing that could be done to mitigate it in the individual case. So, Baroness Hell makes clear, a declaration of incompatibility is not a declaration that the legislation always operates incompatibly with convention rights. It's a declaration only that it is capable of operating incompatibly, and almost always that it has operated incompatibly in the case before the court. And your lordships then read down to 53, fourth line down. The beauty of its declaration was that while it alerted Parliament to the fact that, for this is the Court of Appeal, that for the reasons given in the Court's judgment, the 77 Act was capable of operating incompatibly with Convention rights and so required amendment, it did not affect the validity, continuing operation or enforcement of the Act. And although the Secretary of State and the Home Department contends that by her amendments of the 2013 Act she has remedied the incompatibility identified with the Court of Appeal, its declaration when made was rightly made, and it seems logical in the context of an appeal not now to set it aside. So the effect of a declaration is in no sense that the court is interfering with Parliament's sovereignty. You're leaving it to the court, you're just to Parliament, you're just alerting Parliament to the fact that this scheme is incompatible, and Parliament can then decide what to do. And more on the effect of a declaration is said by the Supreme Court in Steinfeld at tab 37, paragraph 59. So that's Steinfeld, Authorities 37, tab 59. Sorry, paragraph 59. Through to 61, 59 to 61. The alternative, so for those reasons, if the court concludes that the scheme is unjustifiable or leads to unjustifiable discrimination on grounds of race and nationality, it has to ask itself the question, well, what can be done, if anything, whilst preserving the legislation, whether by promulgation of policies, rules and so forth, to stop that. And if it concludes that nothing can be done, as the Secretary of State himself asserts, and we agree, then in our submission it is entirely appropriate to make a declaration of incompatibility. Can I then turn to the declaration of irrationality? And the government's case on this is it's entirely premature. This challenge was premature because it had not made a decision to roll out. And I will make clear what we had an argument about in the court below, which is that our challenge is not to the decision to roll out the scheme. Our challenge, our case as to what was irrational, was the decision not to conduct a further evaluation of the impact of the scheme and its efficacy before rolling out. And that was clear in our detailed statement of facts and grounds. If your lordships turn to page 220, where our detailed statement of facts and grounds are, and to page 221, paragraph 4, Roman numeral 2. We seek an order on 221, paragraph 2, declaring that a decision by the defendant to commence the scheme in Scotland or Wales without further evaluation of its discriminatory impact would be irrational. So that's the decision that would be irrational. And then if one looks in the grounds at page 246, paragraphs 87 and 89, the same point is again made. So that's the decision that the judge was having to engage with that was under challenge. And this was a fallback argument. So the argument arose in the event that the court were to conclude that the work done by others, i.e. not by the Secretary of State, but through the surveys, the work done by JCWI with their limited means and resources, if the court were to conclude that that work was insufficient to establish the discrimination, then our case was, what it certainly does is put the Secretary of State on notice that this scheme is, in its application and operation, doing something very different to what Parliament anticipated, involving a cost that Parliament did not itself contemplate and include in its balancing exercise, and that therefore, before rolling it out further, the Secretary of State, as a matter of rationality, had to get to the truth and find out what was going on and whether or not it was, in fact, doing what the evidence strongly suggested, in fact proved on the judge's findings, but strongly suggested the scheme was doing, and to then carry out a proper evaluation of the impact of the scheme so that the costs and benefits could properly be weighed against each other. So as to whether that decision had been taken, there is a wealth of material that makes that plain. So first, there was the position of the government after the first pilot, and the independent Chief Inspector of Borders, David Bolt, in his report at paragraph 3.15, this is on page 362, noted paragraph 3.15, page 362, in relation to further evaluation and monitoring, in January 16, the Immigration Minister explained to LCP members that there were no formal plans, but the department did keep all policies under review. So no formal plans at that point. And then when the parties engaged in pre-action correspondence, the appellant wrote to the respondent on the 26th of May of 2017, that is in the supplementary bundle. If you turn to tab E, right at the back, and to 20, yeah, so you've got to turn to page 545. The letter starts of the 26th of May at 544. at the very bottom of the page, the claimant states that the defendant must, prior to rolling out the scheme to Wales, Northern Ireland and Scotland, address the findings of a report by the claimant, conduct her own research into the impact of the scheme and whether it is operated in a discriminatory way, and publish and consult on this further research. And if your lordships then read the response, the defendant's position, what's the government's intention that the scheme should apply across the rest of the UK, and officials had engaged with their counterparts in the devolved administrations on a preparatory basis. There's been no decision. This is at the time when also we were looking at fresh elections. The claimant is reminded that a general election has been called, that's the third paragraph down, and we are therefore in a period of purdah. As such, no decision on the extension of the scheme, this is at the bottom of that paragraph, will be taken until a new government is formed. And then there is a question at 3, whether the claimant's report has been reviewed, and whether at 4, whether further research has been undertaken, and at 5, does the defendant propose to undertake any further research? And if your lordships read the answers to that.
I'm afraid I don't seem to have pages 520 onwards.
Oh, I am so sorry, my lord.
So I've got all of the skeleton arguments. And I apologise if it's my fault, it may well be.
So for your lordships note, we were looking at page 544
Yes.
through to 546, which is correspondence from the
Lord
appellant.
Justice Henderson, we do have the pages.
So for your lordship's note, it was the bottom of page 544 and then the top paragraph, the defendant's position, on 545, and then 3, 4 and 5 as one moves down the page and onto page 546. So those answers were given, and then at the time of implementation, the position that the defendant was taking is set out at C141. This is in the impact assessment. Monitoring and evaluation, the Home Office at the very bottom of the page, at the very bottom, the effectiveness of the new regime would be monitored by a civil penalties unit to be operated within the Home Office. Home Office at the bottom will monitor any changes to the volumes of voluntary returns and will fully review the implementation and operation of the policy after 2 years. So the question then arose that what was meant by 2 years? And so that was another issue that was engaged in correspondence. And we go back to D and to a letter of the 31st of October, so sorry, back to E. Oh no, it is, yes, E, a letter of the 31st of October, which is 37 or 38. And I hope you have this right at the back. It's not actually numbered. It doesn't continue 556. In my copy, it stands alone as D37, which is the numbering from the old bundle. Do you have a letter of the 31st of October?
That's 556, I do now.
Ah, you have it as 556.
556.
Yeah.
And you have it. Good. So the defendant's position at the bottom of that letter, the defendant's position remains unchanged and she relies upon the previous correspondence on her behalf. And if you will then read the next page, so the 2 years is 2 years after implementation across the whole of the United Kingdom, i.e. no further evaluation before that rollout. And then Mr Patel met after the general election with officials from the Home Office, and in his statement at paragraph 83, That's A29. He addresses what he was told. Paragraph 83, page 29. From a meeting I attended with the Home Office policy team and other Home Office employees regarding the right to rent scheme in July 2017, I understand that no such evaluation or monitoring is contemplated for the future. In that meeting, we discussed the report to which, in my view, the Home Office gave a satisfactory response, etc. You read on there. And then Mr. Asmat's statement, B112 to 113. At the bottom, paragraphs 81 to 80.
Which page on the bundle?
I'm so sorry, 112 to 113.
The bundle?
It's in the supplementary bundle, page 112 to 113. And at the bottom, paragraphs 81 to 83.
Yep. Yes.
So before any decision's taken, we'll do a policy equality statement, but we're not going to do it on the basis of any new evaluation ourselves. We'll just look at the evidence that is out there. And yes, we'll hold off doing anything until the judgment of this court. But again, that doesn't entail any evaluation on the part of the government before rolling out. So very, very clear. And I should say, at B, I also have a reference, March 2018, Home Office response to the Independent Chief Inspector of Borders and Immigration report. It was not proposing to evaluate for discrimination. And the reference there is to B719 in the original High Court bundles, which I think we have. Make available to your lordships. Yes, so this is paragraph 4.1. The recommendation of the Chief Inspector had been.
So sorry, Ms. Coughlin. Where are we?
So this is the original bundles, and there is a further response to the Chief Inspector of Immigration.
Is this in the bundles for us?
It's in the original bundles, and we
I see,
had
see.
them, so we brought them just in case not
All right.
everything was in there. So there is one page that it may be worth us providing you with. It just is more of the same. It makes clear there is not going to be a further evaluation.
Okay.
And I'll read it, and then we can make sure that you have a copy rather than sending you the whole bundles. But the recommendation was, it included that with the new consultative panel, that the government should develop and make plans for the monitoring and evaluation of the right to rent measures, including, but not limited to, the impact of the measures on illegal migrants, on landlords, on racial or other discrimination, and so forth. And the government responded, while we do not consider that a new consultative panel should be formed, we accept the benefits of further monitoring and evaluation of the right to rent measures. As a result, the Home Office will continue to monitor key related indicators, including homelessness figures and levels of landlord non-compliance. That's numbers of civil penalty notices and prosecutions. It will also explore how best to further assess awareness and take-up of the scheme to fill in gaps in understanding, i.e. absolutely nothing whatsoever on evaluating discrimination and so forth. So it's just more consistent. We're not going to evaluate this scheme any further to understand its discriminatory impacts before we roll out. Oh, and we,
EHRC's.
oh, the EHRC submissions quote that at page 442, so you will find that at paragraph 19, 20 of the EHRC's submissions. So the judge was perfectly entitled to proceed on the basis that a decision had been taken, that there would be no further evaluation, and it was that decision that was under challenge, not premature. It's entirely proper to consider whether or not, in light of all the evidence that there being, whether a decision could rationally be taken to roll out a scheme further where the cost had not itself already been taken into account when the scheme was originally enacted, where it's having this effect, or there is very strong evidence showing that there is a serious risk that despite all efforts it is having this effect, so that the government should stop and ask itself what is happening, and do we think it is proportionate and justifiable to roll this scheme out at this stage in light of what is happening. And we do rely, in addition, not only on a question of common law rationality, is it rational to run full steam ahead and implement a scheme that is causing landlords to act unlawfully, or is it, that's the simple question, without further trying to understand what is actually happening. And in our submission there is a very obvious answer: no responsible government should be rushing ahead without understanding and taking on board the full implications of what it has done and the unforeseen consequences before it seeks to roll it out further. But it's also, so that's irrationality, and his decision cannot be impugned for that, but it's also, and this will be elaborated on by Mr. Armstrong, it is also entirely contrary to the public sector equality duty that the state is obliged to comply with, which obviously further feeds into why it is irrational to drive ahead in the face of such a serious risk of further unfolding illegality across the country, impacting upon black and ethnic minority British citizens and those who are perfectly lawfully here and entitled to be here, but are foreign nationals. So, again, in our submission, a proper decision to challenge, not premature, and entirely within his discretion to conclude that there was irrationality. Unless I can assist your lordships any further.
That's very helpful, Ms. Catherine, thank you very much. Right, which one of the interveners is going to go first?
That falls to me on behalf of the RLA. So
Right.
the plan is the RLA for 20 minutes, then Liberty for 25, and the Equality and Human Rights Commission for, I think, 15 at the end.
I thought it was 20 minutes each, wasn't it?
Yes, the Equality and Human Rights Commission have given up 5 of their minutes to Liberty. So,
Right. You're asking our permission, are you?
no, I'm sticking to my 20
All right,
minutes.
crack on, anyway.
I'll carry on. And in those 20 minutes, on behalf of the RLA, there are 3 areas I'd like to address.
Yes, you may have gathered from some of the comments
I
on the
can
bench
I can see which way these
where the
these
judicial wind is
questions
blowing at the moment, but we're always ready to have us put back on what you say is the right course. Of course we are.
The first area I need to address briefly is the nature of the private rented sector and the market and how the scheme interacts with the market. The second area I'd like to address is the regulatory impact of this scheme, both as a scheme and how it interacts.
So my fault.
Sorry.
Your first point again, I'm so
So
sorry.
my first point is the nature of the private rented sector
Vibrant centre, yep.
and the market in which we are operating.
Yep.
The second is the regulatory impact of this scheme and how it interacts with the wider regulatory position in the private rented sector.
Yep.
And then the third, and the area that I suspect you'll have most interest in, given your questions to Ms. Coltman earlier, is why we say that those 2 factors, the nature of market pressure and regulatory factors, provide an incentive for landlords to adopt a safety-first approach. It is not a question of discrimination, or unlawful discrimination against any potential tenant. And I'll be seeking to try and persuade you that it's a practice of preferring a tenant who can immediately and simply prove compliance or sufficient compliance to reduce a landlord's risk. Given the limited time available to me, I'm not going to take you to the underlying evidence, but could I ask you to pay particular regard to what David Smith's statement says in supplementary bundle, page 415, paras 9 to 11, 15 to 28, in particular 28, 32 to 42, and our skeleton below, pages 508 to 519 in the supplementary bundle. I start with my first point in the nature of the private rented sector, and I start by reminding the court, as His Lordship accepted below, that private landlordism in England is a relatively unsophisticated business. It's conducted primarily by very small-scale landlords, 62% holding just one rented property, a mean portfolio size of 2.7 properties, and as Mr. Smith's evidence shows, a significant growth in the lodger landlord market since 2009. And that small scale is important because it's that small individual landlord with the one property that this scheme has to act upon. And it's that one individual who has to respond to the pressures of the scheme. Linked to that, the primary driver...
Does the scheme apply to Airbnb?
Would it apply to Airbnb? Yes, it would. The only things it doesn't apply to are those that are set out in Schedule 3 of the Act. So it doesn't apply, for example, to mobile homes.
No.
It doesn't apply to long leases.
Local authority accommodation.
Local authority accommodation is exempt.
But it does apply to licenses, that's the important point.
It does, yes.
So
It
does
applies to
include
licenses.
lodgers.
To include lodgers.
Yes.
So even if,
It applies to anyone occupying residential premises
Yes.
as their home in simplistic terms.
setting, yes.
It doesn't care for the,
I thought.
for the lease
Thank you.
license
Yep.
distinction. And the nature of that market is important because, as I was suggesting earlier, that's who this has to act upon, that very small scale landlord. But more than that, the other pressure, the single most important pressure in the private rented sector is, as you saw from the evidence below, the need to avoid a void period and the need to ensure letting as quickly as possible. Not simply because that's how you maximise your rental income, but because a void period also represents a significant administrative burden for a landlord. You would have to re-register for council tax for a short period, and similar obligations arise. So where you have a scheme that creates delay, as this scheme does, it sits very uncomfortably with the market pressures that act upon landlords. And that delay arises in at least 3 scenarios. The first is, if you have a tenant or a prospective tenant who can't immediately prove that they have a right to rent via an easily understandable document such as a UK passport, then the landlord needs to know whether what's being provided is adequate. There's 2 difficulties with that. The first, as I think Lord Justice Henderson hinted at yesterday, is many landlords are simply unlikely to know what constitutes I think the example was a Lithuanian passport that would be a valid List A category document. And that problem is compounded, as Mr. Smith explains in his witness statement, by the fact that there is nowhere any accessible pictorial documentation to show you what these things look like. You can't go onto the internet and find a comprehensive list of every single form of European Union ID card and passport. And he explains in his statement that he's asked the Secretary of State's officials if they could produce such a document, and they say it can't be done. He draws attention to an incomplete one that's produced by a European Union institution. So you have a situation where a landlord is presented with a document that he recognises, a British passport, and another document that he may never have seen before in his life, and which he's now going to have to go and find out if that is an acceptable document to satisfy the right to rent checks. And the first difficulty he hits is that takes time, and the second difficulty he hits is there is no single place he can go to find out that information. He's got to do that, not just for the person who presents himself as the prospective tenant, but for any other adult that tenant might be authorising to live there. Now, depending on the size of the property, that is potentially quite a repetitive process involving checking a number of documents, possibly not even all provided at the same time. And that fits very uncomfortably with the market requirement for a prompt letting. The second aspect of delay that's built into the scheme concerns the government check-in service. It's not right to say, as was suggested yesterday, that the checking service only applies to certain limited categories of people. In the supplementary bundle, this is just for your note, at page 381, the checking service is what you're told to use for the Windrush generation. Those people who've been in the UK lawfully for such a long period of time that they don't have documents. So the checking service is held up as part of the solution to the Windrush scandal. So potentially the entirety of the Windrush generation who present themselves as a prospective tenant, the landlord has to use the checking service. I say for your reference, supplementary bundle, page 381. That checking service, as Mr. Smith explains in his evidence, can take between 2 and 6 days, and that is simply incompatible with the demands of the market.
So, but after 2 days, you can just go ahead, can't you?
After 2 days, you have a defence to the civil penalty element, yes. So after 2 days, if there's no reply, you can proceed and you can use that as a defence to the civil penalty element. But I'll come on in a moment to the regulatory scheme and the penalties it imposes, because there's one penalty which you cannot protect yourself against, which hasn't been touched on yet, but I'll explain to you how there is one circumstance in which landlords cannot protect against a risk they're exposed to.
In general terms, the delay of 2 working days can hardly be regarded as extravagant or onerous, can it? I mean, it is a minor further disadvantage, but it applies to all landlords across the country. It's not as though some are getting a competitive advantage. It's just a new statutory requirement which has to be complied with.
The point that Mr. Smith makes in his evidence is that the comparator is between 2 people, one of whom turns up immediately showing you a passport, one of whom says, I think I have a right to rent, you need to go and check. He explains that in practice, tenancies don't tend to be entered into until incredibly close to the end of the last tenancy, so as to avoid that void period. So I appreciate 48 working hours isn't long in an objective sense, but in the reality of this market, that's why you prefer one over the other. This may be a point just to make another point. The reality of the private rented sector is that landlords have to make that kind of assessment about who presents the lowest risk on all of their lettings. Imagine that you have 2 tenants who present themselves entirely alike in terms of all relevant protected characteristics in terms of income, but one offers a guarantor for the rent from their parents, say. That person gets the tenancy. The entirety of the private rented sector, because of its small, unsophisticated nature, is about reducing your risk. And what this system does is create risk. It creates a risk, at the moment I'm explaining, of a void period. Thus far we've been discussing a circumstance in which you have a tenant who could potentially prove that they have a lasting right to rent. Of course, it gets even more difficult with time-limited right to rent, because you'll need to remember to diarise when that runs out. In the case of multiple people occupying, you could therefore need to carry out multiple re-evaluations during the life of a tenancy. It's no more and no less than another factor that would drive a landlord to prefer the quicker and easier option and the lower risk option. The second of my areas was regulatory risk. I won't trouble you with the criminal offences and civil penalties, because you've heard about those already, but there's a third regulatory risk arising out of the scheme, to which there is no solution. This is the situation where the Secretary of State can compel landlords to seek possession against a person who has no right to rent. And that risk arises even if you've done the right to rent checks properly. You may have carried out a check in good faith, seen a document that you think complies, kept a proper record of it, but the Secretary of State nonetheless decides the person doesn't have a right to rent. As we explain in our written submissions, what happens then is the Secretary of State serves a notice on you. If you don't take steps to evict, you lose the defence to criminal proceeding. So in effect, you are compelled to take steps to evict. That could be because, and that situation can't be protected against, because even if you think you've done it properly, there could still be a forged document, as we put to Ms. Kaufman yesterday. And that isn't a hypothetical scenario. That was a version of what happened in the linked case in the High Court. So in the High Court, we were heard with a case called Goshvili. I'd be grateful if in your time you could read it. It's at tab 41 of the authorities bundle. But in Goshvili, what had happened? The tenant had presented herself and been offered the tenancy. The landlord hadn't carried out any right to rent checks. The Secretary of State served the notice on him saying you have an illegal immigrant in your property. He started possession proceedings, as he's required to do. It transpired, however, she did have a right to rent. As the judge explains, that students at Liverpool University managed to work out that she'd been here for so long, she qualified under some amnesty scheme. So even if that landlord had done the check, he would have had no way of discovering she had a right to rent. There's discussion of the Goshvili case, and there's discussion of it in Mr. Smith's witness statement as well. Goshvili results in the landlord in that case having to issue possession proceedings at his own cost for a wholly futile claim, which was doomed to fail because it was predicated on her not having a right to rent, and she did. And that's the one risk under this scheme that the Secretary of State can't protect against. He doesn't, for example, offer an undertaking in costs if it turns out he was wrong to serve the notice on the landlord. He doesn't offer an undertaking in relation to reletting costs. He simply leaves it to landlords to evict, knowing that if they don't, they lose the defence to the subsequent criminal prosecution. Again, that is a risk that can be avoided, or minimised rather, by adopting a crude, but a reasonably effective approach of preferring British passports. I do also say you need to see this in the context of the wider regulation of the private rented sector. We explained in our written submissions about the consequences that would flow for a landlord who was convicted of an offence under the right to rent scheme. He'd face what's called a banning order under the Housing and Planning Act 2016. A banning order means that you are prohibited for a period of at least 12 months, potentially unlimited, from engaging in any landlord activity. He'd almost certainly lose his Housing Act 2004 licence. So money, I won't go into them all now, but there are 3 different types of licensing scheme under the Housing Act 2004. If you have a banning order made against you, you must have your licence revoked. It's a crime to let without one of these licences. If you have a conviction under the right to rent legislation, it's nigh on impossible to see how you could ever successfully apply for a licence in the future under the Housing Act 2004. You'd find it very difficult to show that you were a fit and proper person in relation to the letting of premises, for example. You can avoid all of that or minimise that risk by adopting the British passport approach. Which then brings me to the third area, and the impact of the scheme on landlords and what they're doing. Here, respectfully, we say there are 2 different things that need to be borne in mind. What this case is about, and what the evidence shows, is that the response of landlords as a class has been to adopt practices that are having a discriminatory effect. That does not mean that any individual landlord is engaging in an act of unlawful discrimination. Because you would need to know in any individual landlord's case what the reason for that discrimination is. Now, if it's direct discrimination, that is a particular problem, incapable of justification, but the majority of the discrimination is likely to be indirect discrimination. A prima facie neutral rule of letting to the first person who can prove they have a List A document is prima facie neutral, so therefore capable of being justified. And that, we say, is where the Secretary of State's guidance, and Ms. Kaufman took you to yesterday, is so important. And this is the one document I do want to take you to in the Supplemental bundle, page 182M. If I may.
4 minutes to go, Mr. Bates. Use your time wisely.
I thought, yes. 182.
102, yes.
The last substantive paragraph, starting if a person is not able to produce acceptable documents. The critical parts of that are subject to business requirements, try, and are not obliged to do so. That envisages that a policy of preferring the first person to prove they satisfy the requirements is potentially indirectly discriminatory, but potentially therefore justifiable. Because if it were direct discrimination, questions about business requirements, etc. wouldn't arise, because it couldn't be capable of being justified. The author of this guidance in that paragraph appreciates how fast-moving the private rented sector is and appreciates the limitations on landlords' abilities to wait. And what that paragraph is saying is that the policies that individual landlords are adopting, as seen in the evidence, is, if anything, likely to be indirectly discriminatory and capable of being justified, so not unlawfully discriminatory. So the questions that are being put to Ms. Kaufman and named possibly at me a bit later on, it's not that landlords are simply ignoring the law. The market has responded to this legislation by developing a preference for British passports. But whether any individual landlord is committing unlawful discrimination as a result is much, much harder to say. And it's not a question of me standing here on behalf of the RLA saying that landlords want to ignore the law. I am saying to you that because of the drivers in the market and the regulatory framework, if there is individual discrimination, it is likely to be indirect and therefore potentially capable of justification and so not unlawful. And that's the answer.
You can certainly say this is not like a landlord who deliberately fails to put in smoke alarm detectors or deliberately fails to install furniture which is compliant with fire regulation. It's quite different from... That's very inconvenient for landlords, but the fact is they've simply got to do it.
Or from middle of this year, the new ones relating to electrical safety tests. Yes, there are a whole manner of health and safety checks in particular that are just mandated and you have to comply with them. A landlord who didn't do that has nowhere to go. He commits offences. A landlord who is adopting
that's quite different from the present kind of situation.
A landlord who adopts a policy which is prima facie neutral because of the external pressures on the business is potentially committing an act of discrimination, but it will probably be indirect and therefore potentially lawful. And that's why I say respectfully, submissions put yesterday and questions from the bench, the conflation of those two things is the problem. The market has responded in a way that is causing discrimination. That is what the evidence shows. Whether an individual landlord is engaging in unlawful discrimination is an entirely different thing. I've overrun my 4, so
You have.
I should stop, I think.
Thank you very much. That's very helpful, Mr. Bates. That's very helpful indeed. Thank you very much. Mr. Westgate, to you next.
Yes, I'm going to start with ambit, make a few points about that, about the positive modalities and deal with why we say this case can properly be analysed as positive modality. Then I'm going to have a few points to make about state responsibility, but a lot of that's already been covered by Ms. Kaufman. I don't propose to repeat what she's said. As far as ambit's concerned, the overall approach in Strasbourg is, I think, common ground, a non-technical one, which asks whether the facts at issue or the facts of the case fall within the ambit or scope of Article 8. It's sometimes described as the subject matter of the disadvantage being one of the modalities of the relevant article, or the measures complained of being linked to the exercise of the right guaranteed. All of those come from Petrovich. But that raises a question here, which is what are the facts that we have to be concerned with? And I raise that because there is, and it may become particularly relevant if it's necessary to look at impact in order to decide whether or not the facts are within the ambit. Because although what we're concerned with specifically in the JCWI challenge is the cohort of people who have the right to rent with which they're concerned, It of course takes place against the background of a broader scheme, which is directed towards a particular target group, where there is a particular aim against them. And what we say is that the facts have to include that group as well, because those are the measures complained of, or the facts at issue. The fact is that the JCWI cohort, if I can put it that way, are victims of that scheme, even if they're not intended victims of that scheme, and therefore the impacts of that scheme on that group are facts that have to be, and the objects of that scheme are facts that have to be taken into account when deciding whether or not the facts overall fall within the ambit of Article 8. Put another way, the respondents can't have it both ways. They suggest that they can rely on what they say are the virtues of the scheme overall when it comes to justification, and relying on the way in which Parliament assessed the matter, but they can't say that that is somehow exhausted when it comes to be considered in relation to the unintended victims. And the reason I raise that is that it perhaps puts into slightly sharper focus some of the points that one can rely on about the nature of the impact of the scheme overall. It's intended to make it more difficult to establish a life in the UK. It's also, according to Mr. Asmat, and this is Supplemental Bundle 101 and 100, intended to ease pressure on the housing market and to avoid exploitation by rogue landlords. He refers there to the scandal of beds in sheds. It's page 100 of the Supplementary Bundle. It moreover operates by removing the right of any person to enter into a residential agreement to occupy premises, and that has the effect that excludes those migrants from a range of rights that have been developed over the years, which have the obvious object of being to promote security, safe and dignified housing conditions, and exemptions from seizure, which is a core value of Article 8. Those provisions set out in our skeleton at paragraph 20. And so the target groups are excluded from that altogether. It may be that, and I say may, that the JCWI cohort might have some lesser impact in relation to them, or maybe a shorter term impact, but that's, as noted by the judge, there are some who will not be able to find accommodation at all, and as noted yesterday, that group includes some who are among the most vulnerable. So that's my first general point. So far as negative modality is concerned, we say the judge was right to recognise the existence of what he described in that way, i.e. where there's not a positive mode, but there's no substantive interference with the Article 8 right. He was right to find that nonetheless that could be within the ambit of Article 8. That, we say, is consistent with principle, because Article 14 is directed to secure the enjoyment of the rights and freedoms, and that requires enjoyment of those rights and freedoms to their full extent, and not only to the extent that would otherwise call for justification. We get support from that from the Belgian Police Union case, which is tab 50, paragraph 44, which refers to the Article 14 prohibiting all discrimination. In describing...
Is it sort of happenstance? There seems to be no reported decision on
Well,
negative.
we say Zabadami is an example, which I'll come on to.
Right.
But it may simply be that it's just not a distinction that really preoccupies Strasbourg. The fact is that the positive modality reasoning has become part of our law through analysis following on really from Petrovich. But it's not something that really features as the Strasbourg cases simply don't trouble to articulate the cases.
Well, I think your point is there's no conceptual reason why one should distinguish between positive modalities and negative.
Well, that's right, and certainly what I say is that there are, in very many cases, it's a matter of preference almost, whether you analyse it as positive or negative. And I'll come on to explain that a bit more later.
Not too much later, Mr. Westgate.
No. But what there is what Lord Justice Leggett in SC, which is tab 45, paragraph 44, describes as a penumbral area, where although the right itself isn't engaged, action by the state mustn't violate Article 14. But in describing that area, the Strasbourg case law hasn't limited itself to cases where the state has optionally agreed to confer a benefit. Rather, the cases have described that as illustrative of a principle. You've seen the Belgian police case, which I won't take you to any further, but Petrovich, which is normally taken as being the starting point of the positive modality idea, relies on the Belgian Police Union case as its source for the description of a modality. And of course, if the Belgian police case isn't a positive modality case, as Ms. Kaufman demonstrated it isn't, then Petrovic's reliance on it can't be taken to be limited to that group. Equally, Sir Nicholas Bratzer in Zavadani described the positive modality class of cases as illustrative of the wide ambit, not as constitutive of it. And Zab itself demonstrates that something can fall short of the substantive interference, yet be within the ambit, because in that case, the jury service wasn't within the definition of forced labour, but nonetheless fell, because it was excluded as a normal civic obligation, but it still fell within the sense of forced labour as being exacted under menace of a penalty, and therefore it demonstrates that you can have an interference, and this clearly was a negative case, it wasn't a positive confer of a right, even where there's no question of the substantive right being interfered with. There is, we say, no real conceptual difference between positive and negative modalities, in very many cases, a discriminatory intrusion which falls short of a prima facie interference, yet within the field occupied by Article 8 or its penumbra, will necessarily imply that whatever's been taken away for the disadvantaged group is being maintained for the advantaged group, and therefore going forward can equally be described as a positive modality as much as a negative modality. And it's entirely formalistic to say, well, those are cases where you've taken something away rather than when you've granted something, and there was debate about that. We don't need to have a hypothetical debate about that because there are clear examples of it in the cases. So in Akbar, that was exactly what happened. Formerly, all prisoners had rights to be transferred to open conditions. After the change, that right was taken away from certain categories of foreign national prisoners, but not others. Similarly, you get in DA, which is the benefit cap case, there were benefits that had been maintained and then they were taken away or restricted for some people. So there's a well-recognised class of case where something is taken away, and that falls within the ambit, even though the act complained of plainly isn't conferring a benefit, it's taking one away. In this case, we say that the measure can better be explained as a positive modality. We deal with it in our skeleton of paragraphs 18 to 22, where we explain that there are several ways in which it can be, the grant of tenancies, or the right to grant tenancies, can better be conceptualised as the grant of a positive right. We say that in two ways. One is that, in fact, there isn't a pre-existing common law right for aliens to hold property. They've only had it since 1844, and we deal with the provisions in our skeleton. The appellant says, well, that's simply the removal of the discriminatory provision. Well, what if it is? That can't be a basis for saying that that's a reason for saying that somehow pre-existing rights don't fall within the protection of Article 14. The human rights protection extends to those pre-existing rights, and if they're discriminatory, then those protections should apply. There's a technical reason, as a matter of law, why it's not right, going back to fealty to the Crown, which I won't go into, and it's dealt with in Blackstone. But the second way we put the point is the obstacle created by the right to rent is to agreements to occupy as known your principal home, and that's a gateway to a number of provisions that we set out in paragraph 20. Again, the respondent's objection, the appellant's objection there, is that those are matters that can't be seen to be ones where the right at issue is the objective of the domestic legislation. But that's not, we say, a requirement. We rely on STEC, where the formulation is simply that it applies to those additional rights falling within the general scope of any convention article, for which the states voluntarily decided to provide. So one doesn't need to have some kind of internal articulation of a desire to further ECHR rights, and that can most clearly be seen by the fact that some of the cases are ones where the provision derives from legislation that predated the ECHR, Guidam being an example. So if one does have to go into that, then you simply look at the objective nature of the legislation rather than its subjective nature. I'm not going to say any more about ambit. I'm going to say a little bit about state responsibility. where we say we agree that the foundation to that is Article 14 and the obligation to secure rights without discrimination. Ms. Kaufman took the point that where the state legislates, then it's obviously in terms that expressly authorise discrimination, then it would obviously be responsible for that. There's an example of that in the cases, Gaidan, which is tab 9. But we say it's worth as a matter of principle in considering why the state is liable here, to consider, well, why is it that the state's liable in that kind of case? And we say that the answer is simple, and you get it from paragraph 9 of Gaidan, that in such a case the state has failed to secure the equal enjoyment of the relevant convention right. And if that's the case, then one can't draw a principal distinction between different ways in which those discriminatory effects are produced. And in particular, it's wrong to place almost exclusive emphasis, as the appellant does, on the terms of the legislation, because legislation achieves its effect not simply by the language that it uses, but through the way in which it's promulgated and the way in which it takes its effect in context and in the real world. And the defendant, the appellant, seeks to take advantage of that where it suits them, because they rely on guidance and the fact that it has to be operated compatibly with convention rights and so on. But they've got to take the rough with the smooth on that, because the real world will include the attitudes and preferences to whom the legislation is addressed, and particularly where, as here, it was expressly intended to alter the behaviour of landlords. It's also got to take account of the fact that the landlords to whom it's addressed may not calibrate their behaviour as precisely as the legislator would have wished. And again, that's especially so here, when one considers what the headline message of this legislation is, and this ties in with what this debate has been saying, that message is an exclusionary one. It's do not let to those who don't have a right to rent. And when the landlords act in the way in which the JCWI complain, that's exactly what they're doing. They're falling within that primary message. And the secondary message, which is make sure you don't exclude anyone who does have the right to rent, can perhaps easily be lost sight of in the way in which the legislation is.
I mean, that is a fair point. It's a sort of curious point, but in that sense, the scheme is extremely effective.
Yes, you're certainly not getting landlords incentivising themselves to
renting to those who the government do not want properties to be rented
No.
to.
And as I say, you're entitled to give prominence to the headline message, as I've put it. And there's no principle that state liability is broken by intervening voluntary acts of private individuals. And I just want to make a couple of points on the authorities that you referred to. You were taken to DH and the Czech Republic, tab 63. You went through some of that. We summarise it in paragraph 34 of our skeleton, but we draw attention in particular to some of the features of that. It's a case where the special schools had their own legal personality, which is a matter that was relied on by the government, and the system had been introduced following the introduction of the market economy. The judgment didn't find it necessary to get into what part that played. The statutory provisions are set out at paragraphs 36 and 38, and it's a system that, if it operated properly, wouldn't give rise to the problem, because it refers to a case where someone will go to a special school where there are compelling needs that warrant placement. So it's an example of exactly the kind of thing that Sir James was talking about. It's misapplication of the statutory scheme. It's also a case where parental consent was necessary, and I refer there to paragraphs 46, 148 and 153. And it's also a case where societal prejudice played a significant role. That's paragraph 48. But despite that, the court in its judgment didn't find it necessary to separate out or analyse liability for those various causal factors. They didn't go into the respective roles of the educational psychologists or the schools or the parents. They didn't regard parental consent as breaking the chain of causation in any way, nor the attitudes of other parents. And so what one gets overall is the idea that so long as there is a causal relationship, then Strasbourg does not concern itself to get into the details as to how exactly that's brought about. And that's similarly found in the Grzelek case, which is tab 68. And in that case, again, you were taken through it. It's the one about the religious instruction appearing on an identity card or on records. But what I invite you to look at is page 33 of the report, which is the partly dissenting opinion, and also paragraph 75 of that judgment. And what those make clear is that this was a case where discrimination on religious grounds was prohibited under domestic law, and it's also a case where the government's case was that dealing with that was the responsibility of the school and they'd done everything they could. So in other words, the government's case was, we've made it against the law, we've done what we can to stop it. If there is a problem, it's a problem that's being caused by private individuals, but that didn't succeed for the reasons you've seen.
Which tab is that?
That's tab 68. And it's analogous to the present case where the argument would be, presumably, well, it's regrettable that this harassment takes place, but the state's done what it can and it washes its hands of what's happening at the hands of private individuals. It's also a case that can't be written off as a purely being about education, and so within the educational sphere, because it builds on two earlier cases, Sinan Isik and Sophianopolis, which are both about identity cards. And Sophianopolis, again, was a case where the gist of the reasoning, or part of the reasoning, was that religion appearing on an identity card might stigmatise someone. That's tab 58 at page 8. So I'm not going to develop that any further. The only further point I'd make in relation to so James takes the point in his skeleton and in his submissions that there has to be some kind of nexus in order to make the state liable. That we say isn't found in the authorities, and causation is the key. But if one does want to go further and find some kind of nexus, what one has here is something that goes beyond mere causation and is similar to a situation of delegation. And I refer you there to Costello-Roberts, which is tab 55. You looked at that for a different purpose. And there, the court made clear that the state couldn't escape liability by delegation. It's not entirely clear what they meant by delegation in that context. It can't mean strict delegation or the creation of a relationship of agency. Well, what it seems to be is that a private individual carries out activities that the state would characteristically carry out. And in this case, that is what landlords are doing to a certain extent, because they're engaging in an activity that is subject to regulation and is classically the responsibility of the state, or is in the context of something that's classically the responsibility of the state, and they're engaged in effect, encouraging people to return as part of an exercise of immigration control. And although that we accept that doesn't positively make them agents, it is a relationship which is close to it because they're carrying out, or they're being used as an instrument of immigration control. And we'd invite you to look there at tab 70, the case of Hersey Jammer, at paragraphs 133, 134 and 136 in the opinion of Judge Pinto, which makes clear that immigration control, even when carried out by private individuals, is the responsibility of the state. I'm not going to say any more about state responsibility. The only final point I'd make is to invite you to look at what we say in our skeleton about remedy, paragraphs 45 onwards, because the points that are made about declarations of incompatibility by Sir James, we say, don't take account of the direction of the recent cases, which we summarise there. Would you bear with me? Well, also, I hope I've not exceeded my 25 minutes.
Just one point.
Yes.
If I could ask you this, on your argument, given that we know what the actual objective of this legislative scheme
Yes.
is, can you envisage any way in which there could be such a scheme which would not fall foul of Article 14?
I can't improve, I think, on what Ms. Kaufman's been saying, that
I appreciate in law all you're concerned with is this scheme.
No, yes,
You're entitled to say
and
that,
the
but
difficulty is that
that's the question I would ask you.
this is the case where the challenges to this scheme, the Secretary of State resists putting forward an alternative scheme. They resist putting forward suggested amendments to this scheme. They say, well, there's nothing wrong with this scheme. Yeah. And it's then difficult for anyone in the respondent's position to say, well, here's a scheme. not least because it's enacted for the reasons that the court has made clear. It's for the Secretary of State to. The Secretary of State has the knowledge to devise a scheme and the means of evaluating such a scheme. And anything that the respondent puts forward would be likely to be met with various practical objections that are within the purview of the Secretary of State. But all that the directive requires is a straightforward penalisation of intentional assistance. This scheme clearly goes further than that.
Well, I take that as a polite way of saying you don't wish to answer my question.
Well,
I'm not criticising, but you're entitled to focus simply on this particular scheme.
Yes, well,
just wondering whether
it's fair to say I don't have another scheme I can put to you.
No, which might work.
Beyond the one
well, that's fair enough.
Ms. Kaufman analysed suggested in her submissions.
Very helpful. Yes, Fanny, yes. Mr. Johnson.
My Lords, I appear on behalf of the Commission and I have the pleasure and responsibility of going last, save for Sir James, of course. And I'm going to go last and I'm going to go fast, but please don't take that as meaning that bit I'm concerned with is less important. Because what concerns the Commission is, whatever you make in relation to the discriminatory effect or otherwise of the scheme as it is, do not go further and roll out the scheme, Secretary of State, without doing some further work on it. And so I am concerned only with that declaration, and I am concerned in particular with the PSED bit of that ground, and that alone. My skeleton you can find at, I'm not asking you to turn it up, but it's there and it has much greater detail in it, is at page 429 of the supplementary bundle. And the points that I wish to make very briefly about the public sector equality duty are simply, at this stage, the analysis is both very different to what you've heard for the last 2 days under convention rights, and it is also, the burden is also very different because it is for the Secretary of State to show discharge. And just to deal with, so one of the implications about that, for example, is the extent to which you've heard lots of submissions about the fact that this is third-party discriminators rather than the Secretary of State in that respect, doesn't matter at all within the meaning of the public sector equality duty, because if I can just pick it up, it's at divider 2 of the authorities bundle, so volume 1 of the authorities bundle, and it's right at the back of divider 2.
Which tab, Mr. Arms?
Sorry, tab 2 of the authorities bundle in volume 1. So right at the back, the penultimate page is where you've got the section. Public sector equality duty here, a public authority must, in the exercise of its functions, have due regard to the need to eliminate discrimination, harassment, victimisation, and any other conduct that is prohibited by or under this Act. Now that includes, of course, discrimination that may or may not be unlawful by the landlords. Now, the answer to the question that Mr. Bates has taken you through, sometimes it may not be on the individual facts of an individual case if you've got a particular landlord in question who's got a particular justification, but sometimes, and we would submit quite a lot of the time, it will be, and what section 1491 is asking the Secretary of State to do before rolling out further is think about that, obtain information about it, and analyse it and come up with an answer about how big an impact that is. And I'll come back to other aspects of that in a moment. We support the submissions that Ms. Kaufman made under the convention about it not mattering about it being a third-party discriminator, but in this context it absolutely doesn't matter. Another aspect of this is where Sir James goes through all the materials as he did, making the criticisms that he did about there are gaps in the material. So, for example, the Ministry of Housing letter that you saw from the 11th of December 2018, saying these are the numbers, and Sir James says yes, but that doesn't show why the discrimination is happening. The answer to that is in the PSED context. Well, you find out then, because the obligation is for you to satisfy yourself and to have due regard. Now, the same sorts of points apply in relation to the next bit of section 149, which is under section 1491B, which is you must also consider whether you are advancing opportunity, advancing equality of opportunity between persons who share a relevant protected characteristic and persons who do not. And in this context, that means thinking about those people who do have the relevant documents and those people who do not have the relevant documents. And again, you do have to focus specifically on that question. And just while I'm going through these, can I just make two specific factual points? When the Secretary of State is considering the need to eliminate discrimination and is thinking about whether there is discrimination that is unlawful and is not, you've heard a lot of discussion about what is the effectiveness of the enforcement mechanisms in relation to, and also is it realistic to expect one of the people who might be a victim of this to go to the county court and bring proceedings? And just 2 points about that, again supporting the submissions made by Ms. Kaufman. Firstly, the Commission has looked at this. There is no evidence, nobody is aware of any proceedings ever being brought in the county court by a prospective tenant against a landlord saying you didn't offer me a place and you should have done. And there are very good reasons for that, including, as well as those which were set out by Ms. Kaufman, there are also the costs and legal aid and quantum and the fact that in relation to remedy you can't actually secure that which you want, which is actually securing the tenancy. And for those I just refer you to my skeleton argument of paragraph 4E. But there's also a second point, and just for your note, in the supplementary bundle at the bottom of page 147 and also separately at the top of page 162, when the Secretary of State, the extent to which the Secretary of State looked at this, the Secretary of State looked at the possibility, said, well, there might be unlawful discrimination, but we're producing a code, and the code will have to be taken into account in relation to any proceedings before a tribunal. Said it twice. There are no tribunals here. This is county court litigation, with all of the problems with that, all of the cost rules that apply in relation to that, and all the other disincentives that apply in that formal context. Can I make another specific factual point? My skeleton...
Yes, the usual motivation in any event in such cases would be direct discrimination, wouldn't it?
Well,
which is not what we're talking about.
No, indeed.
But if someone is going to be sufficiently motivated to go to the hassle of county court proceedings, it's likely to be a bad case of direct discrimination, which is truly provocative.
Yes, it would be a terrible case. And you would have to deal with that. They probably just not run you back, is the primary position, that is Kaufman's position. But also, try dealing with the legal aid agency in relation to a case of this kind. You're not going to get there, and you're threatening, cost rules being what they are, all of that. Which is why it has never happened, and this is a scheme that's been in place for the last 4 years now. Now, the other specific point I just wanted to deal with on the facts, and this is my skeleton at paragraph 7, is when you are considering things like the need to advance equality of opportunity, obviously race and nationality is the big issue here, but it isn't the only issue here. You also have the cohort that Ms. Kaufman touched upon because it's in one of the shelter documents, which is those people on fixed leave will very often be people that engage other protected characteristics. Not all of them, but a lot of them will. And the court will know from its immigration work that mental health, for example, is often a key factor in a lot of Article 8 cases. Now, what happens when those Article 8 cases succeed is you are granted, the default position is 30 months of leave. So they're all limited leave cases. That also applies to people like trafficking victims. There are lots of different demographics and lots of different cohorts here. But if you imagine the trafficking victim who has succeeded in establishing that she is a victim of trafficking, has succeeded in establishing that she should not be removed because she's got a private life in the UK, she may be a single mother, maybe all sorts of other things going on, and she is tied to a particular area of support in, say, London with the Poppy Project or whoever it happens to be. She is the person who comes up, and she is you, Secretary of State, need to think about her position. How many people are there in that position? Secretary of State hasn't thought about this at all. There are no numbers or information about any of that. How big is the impact on her? Potentially catastrophic, because this is the first opportunity she's got to establish a platform of support to get her recovery. And are you you tied because you're tied to the Poppy project or a particular psychotherapist or whatever else is going on, a particular area of London, so your ability to find somewhere else is very much more limited. And there are lots of other examples, and I set them out in the skeleton argument, and I accept that some of these groups may be relatively small, but they are small but dramatic impact, and there's no information from the Secretary of State whose duty it is as to how big that group is. So, she is the person who then turns up to the landlord. The landlord looks at her and may be sympathetic but wants to go the convenient line, particularly if the landlord is one of the 62% who is just an owner, is just a lodger, wants a lodger in the room, and is looking at the situation that not only do I need to understand your documents at the moment, I need to diarise it, I need to put an Outlook system in place or whatever it happens to be, and then chase it at the end to see if you've got a new document. If you haven't got a new document, I then need to go down the landlord checking system and sort all of that bit out. There are risks that all of that will go wrong. I just do not want to do this. That is what Mr. Bates is speaking about in relation to that. And bear in mind also this. This is not a criminal sanction case necessarily. This might just be a civil penalty case. And why that matters is the burden is switched to the landlord, because what happens is the Home Office just spits out a penalty notice, and the onus then is on the landlord to A, make an appeal within to make an objection within 28 days, and B, make an appeal within 28 days in order to show that the Home Office has got it wrong. And it's all of that is why the landlord just goes, that's just too much trouble. It really is a lot of trouble, and it would be a lot less trouble, this is why you're getting some of the points you're being made, if this scheme was confined to that which the directive requires and no more. You wouldn't have all of the scale of the problem that you get when you create a civil penalty scheme as well. Just in order to support what I'm saying about the importance of analysing all this, can I just go very briefly, and it will be very briefly, to the only case I'm going to go to, which is Bracking, and that's in volume 2. And I know the court will be, I think all of you will be familiar with Bracking, but I just want to emphasise the point is that divided 21, which in mine I think is volume 2. The bit that is always gone to in Bracking, which I think members of the court have seen before, is paragraph 26, tab 21. So this is the summary of the principles. My lords will remember this was about the decision to close the Independent Living Fund, which was the big community care provision, and it was a case that succeeded in relation to the PSED. And if you just put a line next to paragraph 26, subsection 2, about the evidential requirements, subsection 4 about doing things before you adopt a proposed policy and not merely as a rearguard action, but then in particular subsection 5 and subsection 5 Roman 3, where you've got the oft-cited statement about the duty must be exercised in substance with rigour and with an open mind, and then Roman 5, it is a continuing one. If you then put all of that together with, if we then move forward, and you may want to look at the analysis and the rigour with which the court went through it here, but if you then jump 2 pages ahead to paragraph 60, is the point that it's a heavy burden. So paragraph 60 says, in the end, drawing together the principles and the rival arguments, it seems to me that the 2010 Act imposes a heavy burden upon public authorities in discharging the PSED and ensuring that there is evidence available if necessary to disseminate that discharge. It seems to have been the intention of Parliament that these considerations of equality of opportunity, where they arise, are now to be placed at the centre of formulation of policy by all public authorities, side by side with all other pressing circumstances of whatever magnitude. And this is territory where you are looking at race discrimination and potentially the groups that I am describing. So this is the area where you need to look at it very carefully. And because it's a continuing duty, what you cannot do in my submission, is you can't embark on a course that was embarked upon in 2013 and continue to turn a blind eye to the mounting chorus of evidence coming from lots of sources. And let's bear in mind that they're not just multiple sources, they are people standing in the court today who do not usually stand together. So you've got JCWI and RLA, for example. You've got people coming from different bits of this, all saying the same thing. But as Ms. Kaufman took you through, the Secretary of State says we're not going to do any further evaluation, and that's an obvious breach of the PSED, and there's also an irrationality challenge about that. What you can't do is, in those circumstances, is cling on to a desire to pursue your policy in any event, downplaying the impact. Now, I might go slightly further and controversially than my learned friends about this. This is always about process, not outcome, and it is absolutely not for anybody it's not for this side of the room in particular to say what a compliance scheme would be. But if you start looking at this scheme, it may well end up in a completely different place. Now, you may end up in a situation that it just can't be done. You can't do it in a compliant way. It's not worth the candle. The costs are too great in relation to particular groups. You may end up in a position that says we are only going to do it with a criminal sanction in the way that the directive requires. Or you may end up with some variation, and I don't know what it would be, the groups that were touched upon in Mr. Bates' submissions that are already excluded by Schedule 3, certain kinds of housing being excluded from Schedule 3, you could conceive of circumstances where you might want to expand that group and say, we are particularly concerned in this context with a particular type of accommodation, and the real problem lies that we've got 62% of the sector being very small landlords. So let's, for example, confine it to houses of multiple occupation, or something of that kind. I don't know, it's not for me to put it. It is, however, for the Secretary of State to think about it, and the Secretary of State has not thought about it, has not obtained evidence, has simply stuck to the position that was settled in 2013. And finally, the Secretary of State has stuck to that position, notwithstanding not only the development of the emerging of further evidence, but lots of people saying there is more evidence and you, Secretary of State, need to look at it again. And just for your notes, you have the RLA at supplementary bundle page 398 says you really do need to look at this again. You have the report of David Bolt, the independent inspector, at page 363 says you need to do evaluation. You have Shelter, who said the same thing at page 57 and 58, especially in relation to Scotland and Wales. And the Secretary of State said, well, I'm not going to do it. Now that's the starkness of that position is why JCWI advanced a rationality challenge, but the PSED challenge puts that even more in focus, because you absolutely do have to do it in relation to the PSED. So, and that's why the Commission says clearly, to maintain the rollout with further evaluation is a clear breach of the public sector equality duty. And second, if the court agrees with that, it should say so in a declaration, because declaration is about giving practical help, what is just and convenient in the circumstances. And that would be a practical help, because it would say, all right, whatever the position in relation to the scheme and how it's operating at the moment, support Ms. Kaufman's submissions on that, but you really shouldn't go further without a bit of a rethink, compliantly with the public sector equality duty. And if that's the position, the court should say so in order to declare the position for the benefit of all. Unless I can assist you further, those are my submissions.
Thank you very much. What's you doing? So shall we have your reply tomorrow at 10 o'clock? Would that be right?
All right. I would rather do it at 10:30 if it's not too inconvenient. I've got another meeting tomorrow morning before court, and I anticipate I'm not going to be very long, so we're going to be well done within the time anyway.
Well, 10:30.
I'm very grateful.
My Lord, can I just give you MC in Bulgaria that I mentioned
Oh, yes,
before,
thank you very
which
much.
was the Article 8 case. Paragraphs 148 to 153 deal with Article 8 and positive duties.
Paragraphs?
148 to 153.
Well, I remember, how long will it take council to hopefully agree the note we said we wanted about? I'm looking at junior council here really. How long do you think it'll take you to get it all and agree it? 7 days? Or do you know?
I would hope we'd be able to do it somewhat sooner than that, but I'll
Well, I hope you
consult
would,
my own friend immediately after the adjournment just now.
Could you have a chat about it? But we would like an agreed position stated on this if possible. 10:30 tomorrow.
Guys.